Okay, well, all of you, since you guys are all out of the US, I'm just gonna bounce my way around. I love this.
All right, crew. So I'm going to kick us off. Thank you all for joining us here today on this lovely Wednesday. My name is Hannah. I lead email and community at Growclass. You probably know me. If not, hello, it's nice to meet you. If you're not familiar with Growclass, we're a 6-week growth marketing course and community filled with founders, marketers, freelancers. We teach folks the skills they need to grow their careers and their businesses. Today, I'm really excited to learn about laying the proper legal foundation for your business with our guest, Chandler. So Chandler is an attorney and founder of Lethal Legal, an intellectual property law firm. Her goal since starting her firm has not only been to help protect entrepreneurs, but also help them understand how to make those protections work for them, because that's where the true magic lies. Through her human-centered approach, she's able to break down complex concepts into simple terms that make legal and accessible and understandable to all. Forgive me, there's like people joining at the same time. It's so hard to read while I'm letting people into the room. The more you understand, the more you can leverage the power of all things legal and protect yourself and set yourself up for maximum success. I will drop all of Chandler's links in the chat for you, so you could contact her there if you give me a second. All right, there we go. And if you have any questions for Chandler, we do have time for a Q&A, so feel free to unmute yourself, drop your questions in the chat. If you're feeling a little bit shy, you can private message me and I'll ask the question on your behalf. There's a hand up emoji you can use as well. Just a reminder that there's no such thing as a dumb question. We're all here to learn. This is a judgment-free zone, so as long as you keep it kind and respectful, we'll be okay. But with that being said, I'm going to pass the mic over to Chandler, and we're going to learn how to lay the proper legal foundation for our businesses. Over to you, Chandler. Thanks for coming
Amazing.
today.
Thank you for having me. Okay, I'm going to share my screen with you guys. Okay, so I created a little presentation. Can you guys see this okay? So it checks out. Yeah, everyone can see it. Okay, perfect. So before we dive in, I'm going to teach you guys how to protect yourself today. And this is going to be my version of doing that. I have to give you my disclaimer. Okay. I am an attorney, but I am not your attorney unless you hire me and sign an engagement letter with my firm. This is for educational purposes only. It should not be construed as specific legal advice. Now that I've covered myself, I'm going to teach you guys how to cover yourself. Some of this, a little bit about me, she said, my name's Chandler, hello. Basically, when it comes to the world of law, how many people have been kind of intimidated, or it feels like talking to an attorney, they're going to be stiff, they're going to be arrogant, they're going to just kind of look down on you, stuff like that. That's not my vibe. I hate that. I think that the world of law can be kind of unapproachable. And so I set out to entirely change that narrative. All right. I'm not going to be buttoned up in a suit. I'm coming to you. I'm a normal human. Lawyers are, in fact, just normal humans. I'm sorry if we've led you to believe anything different, but I promise we're not all that bad. So I want to start out by asking you guys a question. And that is, if you were building a house, what would you do first, A or B, and why? Would you lay the foundation or would you paint the walls? Drop an A or B in the chat for me. Lay the foundation. Right, spot on. Totally agree with you. Correct answer is, of course, A, because there's not going to be any walls to paint if you don't first lay that proper foundation for your house. That same concept applies to business, all right? Everyone wants to focus on the fun parts of building a business, which I get because legal doesn't sound super sexy, right? You go to hire a designer, you go to hire someone to help with your copy, you want to hire someone to do the fun things. It is more fun. I can confirm it is more fun to do that. But all of those extra things don't matter unless you have that proper foundation set for your business. Because if one thing goes wrong, your house can just blow over, right? It's not going to be able to weather that storm. So we want a house that not only looks good, but is also strong and sturdy and can really weather any storm that comes its way. So what we're going to cover is an explanation of legal aspects to establishing an unshakable foundation for your business. tangible steps that you can take to secure your business. And I want you guys to really use this as an opportunity to analyze where you're at legally and where you want to be and then how you can get there. I don't want to sit here and just preach at you. That's not my style. I love when things can be interactive and more conversation based, because I think that's where things are most impactful. So if you guys, there will of course be time for Q&A at the end. But if you guys have any questions as we go along, don't hesitate to unmute yourself. Feel free to interrupt me. Feel free to drop a question in the chat. I want to make sure that we're all, on the same page as we continue. As we're going through some of this, I was going to touch on business entities. I'm not going to say a lot on business entities because of the fact that a lot of you are not based in the US. So this will vary a little bit. What I am going to say, just as a general rule of business entities, is that what they do is they protect you liability-wise. So it's going to serve as a shield if someone comes and, worst case, sues you. Having a business entity is what's going to protect you if someone's like, hey, I'm going to come and I'm going to, you breached this contract or you did X, Y, Z. If someone tries you, it's what's going to prevent them from reaching through and accessing your personal assets, meaning you don't want someone coming to take your house, your keys, your car, your kids, whatever it is, right? So it's going to serve as that shield so they can't, quote unquote, pierce the corporate veil. They can't go through that shield and access your personal assets. So that's what a business entity is going to do for you. How a business entity, what it looks like, how it's set up, how it's structured, things are going to look a little bit different in the US compared to, again, outside of the US. So you'll have to refer to someone in your jurisdiction for that specifically. I don't want to advise on that because it will alter a little bit. But as a general rule, that's what a business entity does. And I just want to preface it by saying all of that, and that it's going to just overall establish you as a business, right? It's what makes you an official business owner. I'm going to talk a lot about the difference between a business and a brand, because there is a distinction here. And a lot of people think the terms are used interchangeably. You can use them interchangeably, but they really do mean two completely different things. So another aspect of business and setting yourself up for legal success is intellectual property. What is intellectual property? Intellectual property is intangible creations of the human mind. So it's not something that you can physically touch, but it's still something that you can equally own. All right, there's going to be 3 different types of IP. There's patents, copyrights, and trademarks. Not going to touch too much on patents because they're very nuanced. I don't practice patent law, and they're used for very specific purposes. When it comes to patents, what it's going to protect is inventions. So if you are inventing an entirely new concept, think of the light bulb, the microwave, telephone, computer, things like that. It's a whole new invention. It's going to give you the right to exclude others from making that same invention, reproducing that invention. If other brands want to start selling these inventions, these products that you've created, then they would have to get a license to do so. Okay. When it comes to copyright protection, copyright is going to protect original works of authorship. It's going to protect the form of the expression, but not the subject matter. So just because, for example, I'm talking about legal stuff today does not mean other attorneys can't go and talk about legal stuff, right? Attorneys can still go and talk about legal stuff. They just can't do it in the exact way that I do it and use this exact presentation. So when you are producing, does anyone sell digital products, for example? If anyone sells digital products or wants to sell digital products, drop a 1 in the chat. Or do you have PDFs, or do you have presentations, or do you have anything like that? Yes. Okay. Love it. So what's very interesting is that when you create something, the second pen hits paper, the second a finger snaps a photo, the second fingers hit keyboard, you automatically have a copyright in whatever it is that you created. Okay. It's automatic. It's not something that you have to go separately file for. You automatically have a copyright. However, it is more difficult to enforce if you don't have a registered copyright. So when you have a registered copyright, it makes it a little bit easier to enforce those rights, and you can get higher damages in the event, again, that it is registered, but it is not required. So you know how people use that copyright, and then it has that C symbol and then the year next to their stuff? You can use that too. So I would recommend anything that you're creating, use that. Why not? It's putting other people on notice, like, hey, I created this, it's owned by me, etc., etc. Okay, so that's what I would do if I were you. Understand, again, the second that you create something, you automatically have a copyright. Okay, question. Is there any copyright for the content, image, or music I created using AI? If yes, how to protect them? Amazing question. Okay, I'm glad you asked that. So what's really interesting is kind of this intersection between AI and the law. And the law hasn't caught up right now, right? What I can tell you, the current status is anything that is created by AI is not protected by copyright. You do not have any copyright in whatever you create. Now, the question, then becomes, but you are using creative prompts, you are prompting AI to, your input is what helps create the output, right? You could copyright, your copyright is that input, but that output technically is not made by you. It is artificial intelligence. It is generated by a computer essentially. And so therefore there is no protection in any works that are created using AI. So it's very interesting. It will be even more interesting to see how the law continues to develop as time goes on, and as more people use AI, more things are created by AI, etc. Question: if you design a planner and update the dates each year, do you need to copyright it each year, or is the copywriting the design enough? So two things. I would put the year you created it, and then it depends if are you talking about a digital product, or are you talking about like a physical product? Because if it's a physical product, if it's a digital product, then every year what I would do is I would go in and I would update, like, let's say you put it out in 2020 and it's now 2024. I would update it and say 2020-2024. It's showing that you've had it that long. Okay, question. If you're a photographer, snap a photo and the metadata includes copyright with your name of the business on the original photo. Is that enough, or must it be registered in case someone claims they own your photo and it really was stolen? Good question. So same concept still applies. You automatically have the copyright. No one's arguing that, even if your business is on the photo, if your name is on the photo, any of that. If you want a registered copyright, and if you want those higher damages, then you would need to get it registered. That's just kind of how the system is set up. But here's the other thing. I will say, I'm not one of those attorneys that's like, hey, you need to go copyright every single thing in your business, because I also understand that especially for digital creators, photographers, like that stuff can be not feasible, right? Like that can add up a lot. So I'm not someone who's going to be like, hey, you need to go copyright everything, but I would copyright important things. And for example, if you're a photographer, the other thing that I would do is, if you're working with people, then make sure, and we'll talk about contracts in a second, but make sure you have terms regarding your intellectual property and who retains copyright ownership inside of the agreement. That's another way to protect yourself. Okay, question. Following the above question, REAI, what if the content is created by LLM, trained by our company, but not the Gen AI like ChatGPT? Okay. Okay, what can you explain what LLM is to me? That might be a silly question on my part, but no, because we decided there are no silly questions here. That applies to me too. Okay, LLM. What if content is created by a learning language model trained by our company, but not generative AI like ChatGPT? I would still say no. Anything AI right now is not copyrightable. That is just what the US, or not what the USPTO, but that is just what the US is currently saying. US law designates. It is not. Okay, question. For making, say, a digital download for a business, should we put our name for the copyright or the business name? I would put your business name. Yep, put your business name, your LLC information. Unless you want to personally own it, but I mean, if your business owns it, then it's a business asset, right? So if it's your business putting it out, then I would have it in your business name. Okay, beautiful. Any more questions on copyrights before we move on to trademarks? And if anything comes up, just note it, because we'll, like I said, have a portion at the end for Q&A too. Okay, so moving on, let's talk about trademarks. Copyrights and trademarks often get confused, okay? So when it comes to copyrights, I want you to think of content. Copyright protects content, trademarks protect brands. A trademark is going to be a word, a phrase, a symbol, a slogan, anything that is used to identify a source of goods or services. So for example, your business name could be something that you could trademark, or your brand name could be something that you trademark, but your brand name and your business name don't have to be the same. Remember when I was saying there was a small fine line between the business name and the brand name? That's where this meets, okay? You can have an LLC named whatever you want, or you can have a business entity named whatever you want. That is the name of your business. That could be the same name as your brand, but it doesn't have to be. You can have a different brand name. They do not have to be the same. When you, for example, right, trademarks, think of McDonald's, right, or Nike. Those are going to be word marks. The logo is going to be the swish symbol or the two golden arches for McDonald's, and then the slogan is, you know, just do it or I'm loving it. Those are all kind of different types of trademarks. There's going to be the word mark itself, which is the overall brand name. There's going to be the logo mark, which is the stylized version. Those are two separate things. And then the slogan also. These are all pieces of a brand that people use to identify something, right? I could have just said the slogan and you guys probably would have known what brand I was talking about. So that's how it helps really build that brand recognition and that brand reputation. So let's do a little bit of Mythbusters here, okay? So if you have an LLC, or you can ignore your LLC and just say business entity, right? If you have a business entity, that means you own your brand name or your business name, your brand or your business name, either one. If it's the same, great. If it's different, totally fine. If you have an LLC, do you own your brand name? Drop in the chat, true or false. Okay, someone says true. True. Okay, so the answer here is going to be false. Okay, registering a business entity with the state or wherever you are does not mean that you own your brand name or your business name. Doesn't mean you have any ownership over it. It means you have a business entity. They're two completely different protections. A trademark protects your brand. A business entity protects you liability-wise. Two completely different forms of protection. But a lot of people get confused because they're like, but I have an LLC, or I filed a trade name or DBA, or, you know, whatever it is. So I own. No, you don't. You do not own your brand name. Anyone can come in and use it. They can snatch it. They can steal it. You do not own your brand name. Okay. Same thing with a DBA. If you have a trade name or a DBA, same thing with the domain. You have the domain. You have all the social media handles. You're dominating the industry. You still don't own your brand name. You started the brand. You do not own your brand name. All right. The only way to own your brand is with a registered trademark. The only way to take control of your brand is with a registered trademark. It's the only way you're going to have any type of ownership. Without it, anyone can come and copy you. Anyone can steal your brand name. Anyone can file for it right under your nose. One thing that a lot of people don't know is that and actually I'll touch on that in a second because I want to explain a little bit about the process first. I see someone say, I have applied for a trademark before and it was onerous and time consuming. So the thing about it, well, first of all, I'm sorry you had that experience. If you applied for it on your own, I definitely understand why you would say that. If you applied for it with an attorney, I'm also very sorry you had that experience because it should be very hands-off for you. They should handle it. It's a long process. So that's something that a lot of people think it's just a quick, simple filing. It's not. It is a long, long process. When you file, I mean, but again, you guys have to understand, it's a legal proceeding. A lot of people are like, oh, it's just a filing. No, it's not. It's a whole legal proceeding. Like you are opening a legal case. I don't think anyone thinks legal and thinks easy, right? But sometimes people think, oh, a trademark, it's easy enough. It's really not. There's a lot of nuance that goes into it. And it takes about a year and a quarter before your trademark actually gets registered. It takes a long time. So it's not something that just happens overnight. But what I always tell people is the time is going to pass anyways, right? Time is going to pass. So you might as well file for it now because you're going to get in line to get that ownership. What happens is, and I'll tell you a personal story, I've waited despite knowing what I'm doing, like the back of my hand, you guys, I was kicking myself in the butt. I should have gone on and filed when I had this idea, when I knew what I wanted to trademark, but I didn't. And I waited a few days. I kid you not, 72 hours. I waited 3 days. I just kept putting it to the, pushing back the day. I had a million other things on my to-do list. Should have just gone on and done it. In a matter of that 3-day time span, someone went and filed something that was too close to mine, which means if I would have filed, mine wouldn't have gotten through. I wouldn't have been able to own mine. They would have rejected it. The USPTO would have rejected it and said, nope, you can't own it. It's too similar to something someone else already has. So time is really of the essence if you want ownership of your brand. Okay, question. What about if the name has been in use for a period of time versus someone who has just started using it? It's first to file. First to file. That's who's going to get the trademark. Okay, question. Let's take McDonald's as an example. Do we need to file the registration for the brand name, logo, and slogan separately, or we combine them and file them all at once? Great question. Yep. So what Kate said, images and text are different. That would technically be 3 separate trademarks. So a lot of people think, oh, one and done. And that's actually not the case. Now, again, I'm not that unreasonable attorney that comes in and says, you need to trademark everything all at once, because a lot of times that's not feasible, right? There are legal fees involved in this stuff. I get that. I understand that. With that being said, I think it comes down to prioritizing what's most important. So the word mark is going to be the overall name of your brand. The design mark is going to be the logo, the stylized version. And then of course you have slogans. You could have the name of your podcast. You could trademark your membership. You could trademark if you have a specific signature method or framework, or if you have an online store, or if you have products, right? These are all different things that you can trademark. But again, it's going to come down to how to prioritize it. As a general rule of thumb, I'm always going to recommend starting with the word mark first, meaning the overall name of your brand. Reason being, that's pretty important. Like the name of your brand is really important. If at the end of the day you have to change a logo, I think that's less dire than having to completely rebrand the overall name of your brand, because again, that's what everything is built on. And even same thing with the podcast, the membership, the courses, whatever it is you have underneath your brand. If you have to rebrand those, that's going to suck. But again, it's less dire than having to rebrand the overall name of what everything is built on, right? So when it comes to your logo, what's interesting is, you guys remember the Instagram logo that's like changed? It's changed and evolved. It used to be kind of like that Polaroid looking camera, and now it's more colorful, full of rainbows. Each time it's changed slightly, they have to file a whole new trademark. So that's another reason I recommend starting with the word mark first, because you're less likely to change the name of your brand than you are to change your logo. Especially when you're starting out. My logo's changed a handful of times, right? But one constant is the name of my brand. So definitely think that's important. Okay. Question: how much does trademarking generally cost for a word mark? It definitely does. It depends what country you're in. It depends what country you're in. Yeah. I can attest to what it would cost, in the US. It's also going to depend on who you're working with. I mean, do you want to DIY it? Do you want to hire an attorney? How many categories are you filing? So there's a handful of things. So let me explain a little bit more. So when you file for a trademark, you don't just own it in connection with everything. You only own it in connection with how you use it, right? So brands that are the same name can coexist as long as they're in separate enough categories. And I say that with a really big caveat because it is not what you think is different enough. It's not what I think is different enough. It is what the law says is different enough, right? And so we have to be able to interpret what is genuinely different enough versus what is not. Because I'll have people come to me and they'll be like, Chandler, there's another brand, but they offer branding services for copywriters and I offer branding services for restaurants. And I'm like, great, but you both offer branding services, right? So that's still the same. It's not different enough. What is different enough, for example, is Dove soap versus Dove chocolate. Sure, we're all familiar with those brands. However, you are not going to walk into the soap aisle and start eating it like it's candy, and it's highly unlikely you're going to walk into the candy aisle and start rubbing it all over your body like it's soap, right? Those things are just unlikely to happen. So they say, hey, there's really no likelihood of confusion here. That's the legal terminology, likelihood of confusion. So when we're analyzing, hey, is something similar enough? Is it different enough? There's a variety of different things to take into consideration. And when it comes to trademarking, you want to trademark your brand in connection with all the different ways you use your brand. So there's a handful of different categories that you may or may not have to file in. It could be one category, it could be multiple categories to get that comprehensive protection. Because I'll tell you what, for example, who thinks it would be common sense for beauty tools and skincare products to be in the same category? Right? That would make sense. But they're not. They're in different categories. So when you're filing it in multiple different categories, it's additional filing fees. So each additional category is an additional filing fee. So in the most attorney-like way, I answer that question by saying it depends, because it genuinely does depend. When we say it depends, I promise attorneys aren't just being assholes. We are being so serious. It really does depend. And unless I do a 100% deep dive into your business, it's more than what I can specifically answer on this training. What I will say though, it's generally going to be around like the 2,000 to 3,000 mark is what I would say. As a general rule, again, don't quote me on that, but that's generally what it's going to be around. Okay. Does that answer the questions? Some about trademarks. We're going to dive a little bit deeper because I do have more to explain here on this end. Okay. So I have another question for you guys. Would you move into someone else's apartment if they still live there, or house? You're just like, oh, it's a nice house. I like it. I think I'll just move in. You probably wouldn't do that, right? You're going to make sure no one lives in the house before you move in there. But how did you know? Did you search it first? Did you do a tour, right? Moving into a new place has a couple steps. Number one, you have to check the place out. And then two, you have to actually move in. Starting a brand is similar. So you need to make sure that when you are starting your brand name, that you can actually even use it. AKA, you need to make sure no one else lives in the house that you're trying to move into. When you think of IP, when you think of trademarks, think of it as real estate. It's intellectual real estate. So you can think of it like it's your land, it's your property, right? This is your land. And if you own this land, say you took steps to own your land, and you had a bunch of squatters coming in and pitching tents on your land, what would you do? You'd be like, excuse me, leave. Like, you guys got to go. This isn't your land, right? Similar thing. Before you start a brand, you have to make sure no one else owns the land that you're trying to claim rights to. So you need to clear the name. This should be done anytime you're starting a course, a program, framework, methodology, a podcast, any other asset, not just your overall brand name, but any asset of your brand. All right. The reason I recommend doing this is not just because I'm an attorney and I'm like, hey, you need to trademark every single thing because it's lining my pockets. That's not what I'm saying. The reason I'm telling you this is because of the fact that if you start something and someone else already owns that land and you're like, I'm just going to come in, pitch a tent, they can disengorge you of all the profits you make using that infringing term. Any profit you make in your business, anything you make can be taken if you don't do the proper clearance steps first to make sure that no one else already owns that land. Because if someone else already owns that land and you start capitalizing off of something someone else owns, they can come in and they can say, you have to pay me every single dime that you have made using this term. And I've seen it happen, right? So it's one of those things it's not worth messing around with. You just want to make sure you're covering your bases. Even if you don't go forward and fully own your brand, you want to make sure that you're at least taking those clearance steps. Okay. Second, obviously, then is going to be to actually go ahead and get that trademark. Okay, question. What's the best way to clear your brand name and double check if it's available? All right. I'm going to tell you a way, but I say this with the biggest disclaimer, and it's almost, I'm resistant to share this with people because of the fact that people take it as 100% word and it's not word. Okay. The only way you're going to know for sure is if you work with an attorney, because there's certain, and I don't say that in a biased way, I say that in a real way, because there's certain software that only we have access to. They won't give access to just anyone. They only give access to attorneys because we know how to interpret the results. So we can go in and we can do full clearance searches for you. What you can use, at least, and I'm attesting for the US right now, what you can use to search in the US is a platform called TESS. It's the Trademark Electronic Search System. It is going to be publicly available. Okay, you can type it into Google. Everyone can try this, right? I'm sure you're all Googling TESS right now, so I want you guys to try this. You go to TESS. Okay, here. If you type this TESS into Google, Trademark Electronic Search System, but I'm going to show you why this is scary. Okay, because again, I don't want you guys to take this and run with it and be like, I'm good to go, I cleared the name. No, you kind of just did like, you took, if there's like 10 steps, you took one. Okay, so I would rather you take one step than no steps, but again, it's not the end all be all. I don't want anyone thinking that. So if you type in Starbucks with one S, all of Starbucks trademarks are going to come up. If you type in Starbucks with two S's, nothing is going to come up. That doesn't mean you can go and register Starbucks with two S's. Starbucks is going to be in your inbox with a quickness, okay? For example, another trademark, if you type in, everyone try it right now on TESS. If you have it pulled up, I want you to try it. I want you to type in Jello Skin, one word, JELLOSKIN, Jello Skin, one word. Jello Skin pops up, right? Jello Skin trademarks pop up. Now I want you to separate the word Jello and skin. So Jello space skin. What pops up? Anything? I did this yesterday, so I know. Nothing comes up. All right, so that's what's scary. Just because there's a space, just because there's a the, just because there's an apostrophe or an S at the end of something, these are like the most minor things that can be your downfall if you are only relying on TESS. So again, I give you TESS, but please, please, please do your due diligence and don't use TESS as an absolute word, because it is not. All right. And that's just, I wish there was a better way. I do. But unfortunately, that is what we have publicly available. And it is step one. Okay. Question. What's your advice in separating the brand ownership, like in a trust, away from the business operations? So I guess I don't fully understand your question. I think that would again come down to business entity versus brand ownership. They're two completely different things. I think they are already separate enough, unless I'm misunderstanding your question. Okay. Should you check with every country, example, US, if you want to do business that you want to do business in, even if your business is based, say, in Canada? If you do a lot of business in the US, then yeah, it's something I would check. if it's something that you're like, hey, I'm going to be doing a lot of business here, because you want to make sure that you're not infringing on someone else's business. Even if you don't take the steps to go get another full trademark in the US or in a different country, just making sure that you're not infringing on someone else's business if you are also doing a lot of business here. If you're primarily based in a different country, then it wouldn't be something that I worry about as much. But if you're actively doing business in the US, yes. If you have any resources for Canada, that'd be super nice. Also, how do you know if a trademark is pending? In other words, if someone has filed, since it takes a year-ish, like you said, will this show up in any of the search databases? If the results come up, it will show in the search databases. But again, that's if you are typing in the exact thing, right? So if there's any type of variation, nothing's going to show up, but pending marks will show up in the US or in tests, or pending marks will show up in the, yeah. Okay, perfect. You're seeing pending now. Amazing. Beautiful, beautiful, beautiful. Okay, do we have any more questions about this? Okay, I've kind of gone over this. Too. What can be trademarked? Does anyone have any questions on what can be trademarked? Someone wants to unmute themselves. I'm happy to kind of walk you through what can and can't be trademarked in your business. The other thing is that, yep, absolutely. Go to the previous slide. The other thing is not all trademarks are created equal. So when you are creating brand names, it's important to make sure it's a strong brand name, which unfortunately puts entrepreneurs in a rock and a hard place, because a lot of times people want to create brand names that are very descriptive of what they're offering. Okay, so for example, if you created a product called Digital Product Kit, that's not a very strong name, because you're just explaining what it is. It's a digital product kit, right? Now, if you add your unique identifier before it, then it becomes stronger. So I'll use mine, for example, Lethal Legal's digital product kit. That would be stronger. But if there's no unique identifier, it's not something I would say go get trademarked, right? It's digital product kit it's not a unique identifier. It's not going to help build your reputation by owning that. It would also be hard to enforce, because if someone's just explaining what something is, we can't really stop someone. For example, I can't stop other law firms from using the word law firm, right? That wouldn't be fair. So there's certain words that it's just, they can't be owned. Okay. I'll leave it here for a second. So a lot of people ask, I'll skip a slide down here and I'll just talk about it. A lot of people ask when they should file. And that really depends, but as a general rule, it's going to be as soon as possible, right? Because you want to make sure that no one is coming in and filing before you, because at the end of the day, it's a first to file type of situation. So if someone files before you, then you're kind of SOL. So you want to make sure that you're getting that filing in as soon as possible, so you can get that ownership. The way I explain it, it sounds silly, but it's almost like, and because again, the process takes so long, but it's important to get in line, because if you get in line, it's basically like you're getting in a lunch line. I'm not going to get in the lunch line if there's not going to be food left over for me at the end, meaning I'm not going to file a trademark if it's not going to get registered. However, if I do the proper clearance and I know, okay, if I get in line right now, there will be lunch there for me by the time I'm ready to get served, by the time they review my application, I'm going to get in line as soon as possible, because I want to eat, right? But if I wait a couple more hours, or I wait a few more days, or I wait whatever, there might not be food. There might not be food in it. When a week later, when I try and go and get in line, there might not be food left over for me waiting at that end of that line. So first, file as soon as possible, especially for those things that are priority. Again, if it's like something that you can rename that will be relatively simple, again, name of a course, stuff like that, prioritize filing your brand name first. But again, I still want people to be aware. You have to make sure you're not infringing on someone else's brand, because if you're selling a course and again, we live in this digital age, if you're selling a course and you're infringing on someone else's brand because they have that name or a name that is similar for their course, they can come and say, hey, you have to pay me everything you've made using this name. Every sale you've made, go ahead, just deposit it into my bank account. That sucks. I don't want that for anyone. Okay, so just make sure you're at least doing the due diligence. The other thing is revenue. So like when you have a trademark, it is shown that first-time trademark filers actually make more. You have double the revenue growth. And honestly, it just gives you a more reputable brand. People are like, oh, okay, this is really happening. You're serious about your brand. It also helps you diversify your product suite and just overall become more recognizable. The other big thing is when you have a brand name, there's more opportunities for licensing, meaning you can let someone use your mark if you want to for some type of monetary amount. If you catch someone, again, if you catch someone infringing on your brand, payday for you. You can say, hey, you're infringing on my brand. Now you owe me everything you've made using this term. So it's one of those strategies where if you utilize it, it's there for you, because it's not if someone's going to copy you, it's when. Happens to everyone. There's no one, I don't know anyone that it hasn't happened to at some point. It's just, are you going to be able to leverage the power of your IP when that time arises? Okay. Okay. What happens if you DIY and don't get approved if you apply again with an updated application with the original date applied to your application? Nope, it would not. So, okay, I say the DIY thing with a really big caveat. Here's the thing. At the end of the day, it's a legal proceeding. And especially in the US, I see so many people filing willy-nilly. And it gives me so much anxiety because I see so many DIY applications that are done and they're done incorrectly, and you know they're going to get denied. It is a legal proceeding. I don't want anyone, I mean, no matter where you're at, it's a legal proceeding. So I think that can kind of go, the weight of that isn't necessarily taken into consideration. And I do want everyone to understand, at the end of the day, it's a legal proceeding. I'm not saying it's impossible to DIY it. I'm just saying if you're going to DIY it, you need to do it the right way. With that being said, this is a small plug, but let me say this. I don't recommend DIYing it. I recommend hiring an attorney to do it. If you are set on DIYing it, I created a DIY resource for people to do it the right way. Okay, again, it's not something that I recommend doing, but if you are set on doing it, I have a DIY resource that gives you a foolproof method on how to go ahead and do it. All right, that's going to be called the Asset Protection Program. Again, I don't recommend doing it on your own, but if you are set on doing it on your own, and this is only going to be for people in the US, I also want to give that caveat. If you are based in another country and you want a trademark in the US, you are required to hire US counsel. You cannot file your application on your own. They won't allow you to. I don't make the rules. I'm just telling you what they are so you don't waste money going to file an application and then having them be like, nope, sorry, you actually can't. The whole thing's denied. Okay, Stephen, any tips to create a strong trademarkable name? Yeah, absolutely. So words that are completely made up are going to be the strongest. Sounds crazy, but if you make up a word, it is going to be the absolute strongest. Another strong trademark are normal words, regular words that are used in an irregular way. For example, apple. Okay. Apple is like the fruit, but I say apple and everyone knows, like, hey, here's my iPhone, right? Or here's my MacBook. It's Apple. It's a strong brand name. Completely made up words. Anything that is going to use a strong identifier, even you can even take my word. I would say my brand name would be something like a regular word used in an irregular way, right? Lethal, legal. So words like that are going to be strong. Ones that aren't strong are going to be things that are just descriptive, describing what you're doing. Like I was saying, like digital product kit, right? If you're just describing what you're selling, Like if for example, if the app, let's say Apple Store, and the Apple Store sold apples, that would be descriptive. All right, that would not be something that would be trademarkable, because it's like, okay, you're just telling us what you're selling. Yeah. Do we have any more questions on trademarks? We'll have a chance again at the end, but I am going to talk on contracts now, because I think everyone needs contracts. Okay, I mean, trademarks are important, but like contracts are also so important. And if I don't know how to choose between the two, because it's just, your contracts are going to be the front line of your business, especially when you are working with clients, right? If you, okay, question here. If you work with clients, drop a 1. If you only sell products, drop a 2. 1, 1, 1, 1. Yep. So on some level, most of us are involved in the service-based business, right? Or maybe you do both. Either way, I'm going to tell you, it doesn't matter if you only work with clients one-on-one, 1 and 2, exactly, right? Contracts are equally important, even if you're just selling stuff online and you're not working with clients one-on-one. And actually, I'm going to tell you guys a personal story that happened to me, I kid you not, last week, about selling a digital product, which is funny. Okay, so contracts are going to be the holy grail of your business. They do so much for you. They're going to prevent conflict. They're going to manage expectations, and they highlight commitment between you and whoever else you are working with. I want to say this because a lot of people are like, I've seen so much dialogue on the internet lately that's like, I don't use contracts. Contracts aren't just for you. Like, it's not just for you. It's also for your clients. And it is to protect your clients. Like, yes, contracts, of course, are going to protect you, but they are also equally going to protect your clients. So when you're in business, like, yeah, you want money, but it's not just about you, it's also about your clients. And you want to make sure that you are doing your due diligence to give them just as much protection as you want. Because, for example, if you're doing business without a contract, and I'm not saying anyone here would do this, because I believe you're all stellar humans that would never do this, but if someone pays you and there's no contract in place, what's to prevent you from taking that money and dipping and being like, see ya, it was just a gift. You're just paying me because you think I'm pretty. Right? Like, that doesn't leave your clients any protection. I would not give someone money without a contract in place. This is me telling you, please never give someone money without a contract in place, but also please use contracts for your clients, because again, it's going to protect you, and we'll talk about how they protect you, but also I just want to make it clear, it's also to protect your clients. So some common contract issues that I see are an undefined scope of work, unprotected intellectual property, and unexplained right of recourse. Okay, so in regards to the scope of work, a lot of people are really loose with their language here. The more detailed that you can get, the better. Anytime you can attach a numerical value to something, do so. Okay, and if you can spell it out, if you can type it out and then in parentheses put a number, do that. I mean, any base that you can cover in the scope of work, the scope of services, deliverables, whatever you want to call it, at the end of the day, the more detail you give, the better. In regards to intellectual property, if you are doing work for someone, if you're a photographer, if you're a designer, if you are creating any type of digital assets, if you are, whatever it is you're doing, say you're delivering all the final deliverables to the client, and they decide to just dip out on payments. Then what? You have no right of recourse. That really sucks. Okay, you want to make sure that you say, I'm not, and maybe you want to hold on to all the IP rights. Anyways, if you're a photographer, it's common to hold on to all the copyright in general, which is totally fine and totally fair. However, if you're a designer, for example, and you are creating a logo for someone wants the IP of that logo, because if they want to go trademark it, they don't want you to be like, hey, you can't do that, I own it. It's a nuance a lot of people don't think about, right? So if you retain IP ownership until payment is made in full, It's a good way to protect yourself, because then not only can you go after someone for breach of contract, if they're using the deliverables that you provided them and you retain the copyright ownership, then they're also infringing on your intellectual property. So that's another way to protect yourself in your contracts. Unexplained right of recourse. You want to explain where's the jurisdiction, who has jurisdiction, how is this going to get handled? Will it be handled by filing a suit? Will it be handled via arbitration? Will it be handled via mediation? Things of that nature. It's not always what's in your contract that hurts you. A lot of times it's what's missing from it entirely that is the ultimate downfall. Okay. So let's talk about client service agreements, because a lot of people work with clients here, right? We want to make sure those are super, super tight. Inside of your client service agreement, here's going to be a non-exhaustive list of all of the clauses that should go in there. Again, non-exhaustive, but these are bare minimum need to be inside of the agreement. Question: is it that we can still retain the copyright or patent in the contract even if we have not filed the registration? It wouldn't be a patent, because a patent's an invention, so there wouldn't be any rights to that. But if we're talking about copyright, then yes, you can. Because again, the second pen hits paper, fingers hit keyboard, you create the copyright. So if you are performing work for someone, right? If you're performing work for someone, then you are creating whatever it is. So say it's a design, it's a graphic, whatever. You have that copyright. You haven't filed it, but again, you don't have to file a copyright for it to be yours. I'm just saying the damages are higher if you do register it. But again, if you're performing work for a client, you're not going to go register their copyright, right? If your intention is to transfer the copyright. But that doesn't mean you're SOL, doesn't mean you don't have any damages. I'm just saying the damages are higher if you do register it. Does that clear it up? Okay. So when we think about what goes inside of an agreement, let's take fees, for example. A lot of people are just going to be like, hey, in exchange for me doing XYZ, you owe me XYZ amount of money. But there's so much more that goes into that. There's the cost of services, but what about the fee schedule? Is there a payment plan? What about additional work that's performed? If they want to add on work, at what rate is that going to be done at? How are invoices going to be sent? Are invoices due the day they're sent, or are they due 7 days after or 3 days after? What if someone's late on payment? Are you imposing any late fees? What if someone just stops paying? What if someone defaults on their payments? Then what? What about if you have to expend your own money for additional expenses like font fees, licenses, stuff like that? What happens in those cases, right? So again, it's not always what's in your contract that hurts you, it's what's outside of it. So there's a lot that goes into your agreements to make sure you're protected in a really comprehensive way. The other thing is, it's not just a one and done. Contracts aren't a one size fits all. Different contracts are required for different situations. So you have your service agreements, which is what you're going to use when you work with clients. You also have website agreements that you need. That's going to be your privacy policy and terms of use. You have your hiring agreements, if you're hiring an independent contractor, if you're bringing someone onto your team. You have your collaboration agreements, you have your disclaimers and policies. You have more than on this list. You have your selling agreements. If you're selling digital products, you need digital terms of purchase. If you are, enforcing, there's different enforcement agreements. For example, licensing agreements, cease and desist letters, demand letters, things like that. There are a lot of different kinds of contracts, and different situations require different contracts. You can't just take your client contract and apply it for everything. Okay, so I want to make sure you guys know that. Handful of different types of contracts. Like I said, I was just going through a handful of these. For your website agreements, know that a privacy policy is legally required by law. You need a privacy policy. Okay, it is going to govern how you collect data and how you use it. You need to have this on your website. If you are selling something, I was talking about digital terms of purchase. If you are selling something, you guys need to have digital terms of purchase in place. These are going to be the terms that they check and agree to when they are checking out. Even though you're not working with someone one-on-one, it's still a transaction. So my question is, what happens if they ask for a refund? It's a digital product. Are you going to give it to them? They've gone through all the material. What if they issue a chargeback with their bank? Then what? What would you do in that situation? If you don't have digital terms of purchase, let's take it a step further. Someone downloads your digital product. They're like, I like this. I actually think my audience would love it. So now I'm going to take it and I'm going to sell it. You don't have any terms in your agreement talking about how you retain IP rights to what you're selling. How are they supposed to know they can't do that? How are we supposed to stop them from doing that? Okay, so digital terms of purchase are so important. This is where I'm going to tell you something that happened to me the other day. It doesn't happen often. Yes, of course, Jenna. Great talking with you. Something that happened the other day is that, okay, we'll talk to you guys soon. Love it. Something that happened the other day was that someone tried, this doesn't, like I said, does not happen often, but someone tried issuing a chargeback with their bank with me, with something that they got. Crazy, because I'm just like, first of all, if you come to me, you're like, hey, I need help on something, I'm always more than happy to help. But yeah, they issued a chargeback. So I was not happy, tried communicating with this person. They were like, no, they were saying they never received the product, which they did. And you could go in internally. I have Thrivecart as a platform and you can see they went through the entire product. So I was just astounded. Anyways, my terms of purchase, I use my own digital terms of purchase, by the way, my terms of purchase saved my ass. So instead of the bank, her bank siding with her on that chargeback, they sided with me and I got to retain the money. And I felt like justice was served that day, because it was just like, you completed this whole thing, but people are going to try you, right? I mean, people are trying me, and online I kind of present a little scary, but I promise I'm not. Truly, if people are going to try me, which is crazy, they will certainly try you. Okay. So it's just, you want to be prepared whenever you are selling digital products. Okay. Accessibility is important for websites now as well. I'm not sure the legal policy is the legal. Yep, exactly. For digital terms of purchase, when you're starting out, is it okay to use that could be downloaded on Google? Do you have a recommendation on how to do it when you're starting out? Yes, I absolutely do. And I will get to that. Okay. Because I'm not just going to lay all this on you and leave you guys hanging. All right. Things I want you to focus on: getting a business entity set up. That is what's going to protect you liability wise. Getting effective contracts in place and securing rights to your brand. Reminder, I've said it a million times. I'll say it one more time in case it wasn't clear enough. You don't own your brand unless you have a trademark, right? If you guys walk away with anything today, I want you to walk away with, I need contracts, and you don't own your brand unless you own a trademark. All right. With that being said, a few things. So there's going to be a lethal guide to legal success you guys will have access to. I will send you the link here in a second, but it is going to be a over 70 pages of free information. Utilize it. It includes a lot of good stuff. Okay. Next thing is going to be contract templates. I have contract templates available. I get it's unreasonable. Legal fees are expensive. I get it. Okay. It's hard to go and hire a lawyer for all the different contracts that you need, especially when you're like, I need a client service agreement. I need this. I need website privacy policy. I need terms of use. I need digital terms of purchase. There's a handful of different templates you need. I get it. So I created an accessible alternative to hiring a lawyer. It's inside of the Lethal Legal Shop. Attorney drafted. I've drafted every single one of them. They also come with videos walking you through each step. If you want something that is bundled to where it's a one-time investment and you get access to everything, there's like 30 templates in there, I think now, plus everything I add in the future, it would be smart to do that. You get access to everything. So if you're like, hey, can you add this template? Yes, we can. We will create a template and we will add it, kind of whatever you need. So it's a great alternative to hiring someone, whether you get a individual contract template or you invest in the bundle. It's going to save you a lot of money. And then of course, legal services. If you want help, I'm of course more than happy to help. And if it's something that I can't assist with, I'm more than happy to get you in the hands of someone who can. So if you're like, hey, I need this, but I don't think you necessarily offer this, let me know. I can get you in the hands of someone who can assist you with, whatever problem you're facing. I want to be a resource for you guys. Okay, question, your products are for US law, or do they help Canadians or others? Yes, so for the products, aside from asset protection program, which is the trademark program, for all of the templates, you can absolutely use them if you are based in the US or if you are based in Canada. They are drafted with general contract law principles in mind. You're just going to have to change the jurisdiction information. But again, you would have to do that even if you're in the US. The way it works is everything that you have to change, it's not a lot, but I don't know where you're located. So you kind of have to put where you're located in there, no matter where you're based. It's going to be bracketed and it's going to be highlighted. Okay. I'm setting the links here as well, so you have them, but also you guys get, looking you up, you guys get a 25% discount using the code Growclass. All right, so if you want any of the templates, here are some people who've used them. If you want any of the templates, use code Growclass. It is going to be valid for the next 72 hours and you will get 25% off. So this is definitely something I would use on any individual template. But again, if you want the bundle, I don't discount it a lot because again, it just includes so many contract templates and you get lifetime access and we add everything, any template you need. So if you want the bundle, now would be the time to get it at a discount. But no matter what, go and get the guide. Absolutely go and get the free guide. If you do nothing else, it's free. 70 plus pages. It's going to walk you through a lot of things and go so much more into depth on some of the things we talked about today. Okay. Question, have to hop off as well. Thank you so much. Protecting clients too. Absolutely. Oh my gosh, actually, Monica, what's interesting is I would love to talk to you because I yesterday posted on my stories, if you haven't hopped off yet, I am looking for someone to assist with naming for my clients. So that would be perfect. I'm going to save your email, but if you haven't hopped off yet, please reach out to me as well. I would love to talk. Okay. Thanks.
Oh,
Yay. I'm glad this was helpful, you guys. Does anyone else have questions for me? Speak now or forever hold your peace. I promise I won't.
Final call. Looks like Debbie's got one in the chat.
Would love to trademark, but in the test phase of business, do you still recommend trademarking at this point when you don't know if the business will be sustainable? Good question. So there's two ways to file a trademark. You can file a trademark when you've already launched something, which is a little bit more risky because again, then there's eyes on it, or you can trademark something prior to launching something. That's personally how I've trademarked all of my own brands, and that's how I trademark a lot of my clients' brands. It's just an extra added layer of insurance. I'm not someone who I'm like, hey, if you don't know if your business is going to be successful, do all this stuff. However, my question back to you would be, what are you telling yourself about how successful your business is going to be if you're not taking steps to protect what you're building? Right. So I think there is a mindset piece of it there. I'm someone who I'm reasonable, so I understand it, but I also know that I've gone all in on a lot of things in my life and things tend to play out. So I would take that into consideration. This was helpful. I'm very much in the initiation phase right now, so early, but great insights to have beforehand. Thanks, Chandler. We'll definitely reach out. Absolutely happy to help. Yes, if you guys are here and you have, questions or you just want to say hi, again, DM me on Instagram. Just say hello. I was in the training today. I would love to be able to follow you back and just stay connected. So connect with me there.
All right. Well, looks like we're at the top of the hour. Chandler, this was so great. I learned so much just from being here.
Yes.
Thank you for sharing all your expertise with us. And thank you everyone for your great questions in the chat. Like so many great stuff was being in there that I was like, whoa, great question. Every single one. I was like, oh yeah. So thank you, everyone. I have this recorded so you can watch it again if you missed anything, or if you want to look at the slides again, it'll be in the recording. I will be sharing all the links and the special code in the replay email as well, and in Slack. So keep an eye out for that. Thank you all. Have a great rest of your Wednesday, and I'll see you in your inbox soon. Take it
Thanks.
easy. Thanks, Chandler.
Thank you.
Bye-bye.